methods of enforcement that can deal with the repercussions of rampant drug use. I mean, I think that's a self-solving problem ultimately.
You do?
Yeah. The drug addicts will take themselves out, and it's Darwinism at its probably at its lowest level.
Oh, I don't know. That's going across the air. So this is Mr. Eric Perkins. Mr. Perkins is a local attorney.
Good afternoon.
Nice enough to come on my public access show, which is broadcast on Facebook and YouTube. And
there was a little duress involved.
He didn't have any confidence in me, my technical abilities.
Well, self-evident.
I certainly hope that we have.
This may be on the internet. It may not be on the internet.
Yeah, well, it's on right now because Sylvia Salazar joined. And if Sylvia Salazar has any questions, please feel free to ask them. Mr. Eric Perkins wanted to discuss an article from the National Association of Criminal Defense Lawyers.
It's actually not an article. It's a report that they generated. And it's one of the things that I think probably doesn't. So a lot of people just aren't really thinking about this the way that they're thinking about it regarding the diminution of the number of criminal trials that are actually taking place.
Diminution means less criminal trials than that we used to have. I started to read this article. He sends me like 80 pages. He thinks that I don't have enough work. So
there's a lot of footnotes and there's a lot of pictures.
All right, and this article by the National Association of Criminal Defense Lawyers, you're a member of this, it's probably about $350 a year, $350. You must be one of those rich.
I don't remember. I don't remember.
All right.
I mean, I'd be an active member. They could be coming on here any second trying
Just kidding. And Mr. Greenwell, he'll have some good questions.
Yeah.
This article starts with, there's ample evidence that federal criminal defendants are being coerced to plead guilty because the penalty for exercising their constitutional rights is simply too high to risk. And by constitutional rights, I assume they're meaning your right to a jury trial. Is that correct?
Among others. Now put the report down. Step away. It's not an article. It's
this is a cross-examination.
Yeah, it's
Mr.
actually
Perkins. Didn't you write part of this, or did you have a hand in part of this?
I had nothing. I participated in some of their surveys.
Go ahead.
It's a report generated after a lot of research, a lot of inquiry. They interviewed a lot of federal judges, a lot of federal prosecutors. It does have a pretty heavy emphasis on federal court prosecutions, which are guided, as we know, because you practice in federal court pretty heavily, by the sentencing guidelines, which used to be the Bible. But since Booker, which in some sense is a bit of a fiction, Booker versus the United States, took the sentencing guidelines and put them back in the guideline capacity as opposed to the rule book capacity, which the guidelines were kind of running the show there for a while.
Mr. Perkins is referring to the federal sentencing guidelines, which when they were first passed, they were allegedly mandatory. I actually took that case up to the Fifth Circuit, and they said, yes, they were mandatory. And then they weren't mandatory. So we practice under federal sentencing guidelines in federal court criminal law by a range, by your prior criminal history, so many points for various, for the crime itself, whether or not you had other participants in the case, whether or not it was a conspiracy, whether or not there were guns involved, etc.
Just a myriad of conditions and things that they can look at to adjust the points, which ultimately tell the judges the guideline range for your punishment was expressed in terms of months.
And from memory, which I always object to, I think I've objected to every PSI, pre-sentence investigation reports that applies those guidelines. Basically, from memory, of course, the judge could go above the federal sentencing guidelines for good reasons, or below the federal sentencing guidelines for good stated reasons. Correct? Correct.
Yeah, and we're going to start losing the two people we have right now if we don't get off this pretty quick. But the whole idea behind the report was that the existence of those guidelines and what they call the trial penalty, and the trial penalty, I guess loosely termed, was the penalty that a defendant was apt to face if he forced the government to try his case. And by the government, I mean both the state of Texas or any other state in the union and the federal government. In other words, it began forcing people to accept plea bargains. And plea bargaining, again, is that situation where the prosecution and the defense attorney negotiate something other than a lengthy prison term, often involves probation of some form or other.
Generally, there are no plea bargains in federal court, and they act very much in favor of the criminal defendant, oftentimes in state court, though.
Well, okay, but in the federal court system, what we're talking about in terms of plea bargaining is the acceptance of responsibility. One of the ways a defendant in a federal court can get some immediate reduction of his potential sentence is by, quote unquote, accepting responsibility for his crime. And accepting responsibility is often just nothing more than agreeing to the fact that you are guilty of the offense. And the report seems to suggest that in a lot of different cases, people who are not actually guilty of the federal offense and maybe even the state offense are pleading guilty to avoid the possibility of facing life or lengthy terms of prison, imprisonment. Now, I know you have never done this, and I personally would not allow somebody who has told me that they are in fact not guilty of the offense to plead guilty to a crime, because you've got to get in front of the judge. You have to speak under oath and say that you are guilty. And I tell my clients this: if you're telling me you're not guilty, we're going to trial. We're not going to take a plea bargain, because you can't get up in front of the judge and lie and say that you're guilty of the offense. But in federal court, because of the sentencing guidelines, because there's some fairly distinct and certain punishment right up front that you can calculate for your client, apparently they're finding that there are a number of people, or maybe even a lot of people, who are pleading guilty who are not actually in fact guilty.
Well, the sentences are so lengthy in federal court that oftentimes they will plead guilty. But I will tell you something I don't think this report addresses.
Because you've read the whole thing.
No, well, I looked at it.
You looked at the table.
Okay.
All right, go ahead.
Did they say in fact that many times in federal court you can go to trial and you'll get basically the same sentence if you're found guilty at trial than if you plead guilty?
That's what I found weird about the report.
Okay, so there you go.
It didn't
giving me a hard time on not reading it.
It didn't seem to address the fact that the acceptance responsibility is a fairly low reduction. I mean, it's 2 points, sometimes 3 points off of your total scoring. And it addressed some things that I'm not all that familiar with, because, like you said, there's not a whole lot of plea bargaining, at least not down here in the Southern District.
Right. Let me tell you something else. It's up to the client. I tell the client very often, I go, really doesn't make, if you go to trial and your client does not take the witness stand and he's found guilty, the difference in going to trial and not going to trial, it's almost nothing. Well, because you still ordinarily get the accepted, you'll get acceptance responsibility ordinarily anyway.
Sure. I mean, you can express that during punishment. You can say, I'm sorry, whatever. This report, though, apparently they're talking about some of the Eastern jurisdictions, federal jurisdictions, where apparently there is more plea bargaining taking place.
Right. And the only places basically that I have a practice in is in Victoria Division and in this division. It's very seldom. I don't recall ever getting to Houston or anything on cases like this. But I would agree federal sentencing is very, very lengthy, and it is a severe problem. And many people are pleading guilty, probably to, especially, it's complicated. They're pleading guilty to these conspiracy cases. Are they conspiracies? Should they be? Well, and those are probably the ones I think that there's a serious problem.
This is where some of the plea bargaining comes into play. The report lays a lot of this problem not on the heads of the judges, although it is critical of some federal judges because they don't take a more active role post-Booker in their sentencing options. They really do cede a lot of their authority back to the sentencing guidelines, giving them, again, almost controlling authority over the outcome of the sentence. They put a lot of blame on the prosecutions. First of all, the decision as to how to charge the case. As you know, a lot of times we get multi-count indictments, which invariably include a conspiracy charge if you have multiple defendants. And then the plea bargaining comes into which counts get dismissed as a result of the agreement to enter a plea. And you're usually left with not the underlying offense, but rather you're pleading to a conspiracy count. It's been my experience. The conspiracy counts often carry lower punishment ranges and consequences than the actual offense counts.
Yes, and it's very difficult. And it's very difficult to explain to your criminal defendant. Well, you only dealt with one I only dealt with one person, and I'm charged with this major conspiracy, and I'm responsible for all these drugs, and I dealt with one person.
Well, what's even harder to explain to the defendants is the fact that the guy who set the whole thing up, the kingpin, the mastermind behind the conspiracy, is the first one to run to the U.S. Attorney's office and get a great plea bargain because he's the first in line and he gives everybody else up.
Well, that's not really necessarily a plea bargain. I think that you're probably referring to, allegedly, if you go squeal on enough people, if you rat enough people out, if you inform on enough people. As a matter of fact, President Trump recently referred to it as in some other phrase, and he says he disapproves of it because it involves somebody in his administration. Then allegedly the United States Attorney's Office can go recommend almost any sentence, including nothing.
Sure. No, I mean,
some of the mafia guys got nothing, right?
Sure. 5K1's the street language of cooperation in getting, a reduction or a recommendation. Ultimately, the prosecution can dismiss a case. In McAllen, I've had, clients who cooperated so well that they actually ended up getting probation or dismissals on their cases. So in a sense, that is what they're talking about as far as plea bargaining, the ability of the prosecution to either highly charge the case where you're facing a lot of months in prison, or drop it down and agree to departures. Departures are the ability of the court to move outside of the guideline range in assessing a punishment. So I didn't want to bog us down too much with that. It just happened to be something that's fairly new, that only came out a couple months ago in 2018. And it is getting a lot of attention because of the trial penalty aspect of it. Just the fact that trials seem to be diminishing. And one of the reasons I wanted to bring that up with you is because that's not really happening in Texas, and in particular here in Nueces County. We're trying a lot of cases here.
But federal criminal cases?
Well, federal and state criminal cases.
Well, let's talk about federal criminal. Like I said, I can't really in good faith tell my clients to go ahead and plea bargain. A lot of times they want to, and they do, because there's no incentive to do that. Most of the time they do decide to plead guilty, even without incentive. And I'll tell you why part of that is, in this particular county, it used to be that if you entered a plea of guilty, they would recommend the bottom end of the federal sentencing guidelines.
Right.
Now they say within the federal sentencing guideline range, which is what the judge is going to give you anyway, and you're giving up your right to appeal. So I tell my clients, we're not going to even. I advise them, do not accept this plea bargain within the federal sentencing guidelines, because that's what
the more important part of that is that among the conditions of the plea bargain is that you'd waive your right to appeal. That's right. Which I think is unethical. I think it's malpractice for an attorney to do that. You get nothing in the bargain, and you're giving up an extraordinarily valuable right.
So in other words, you're saying, even though I may not agree with you, that it's kind of malpractice for an attorney in this jurisdiction to advise somebody to actually accept a plea bargain if it's within the federal sentencing guidelines, because you're giving up your right to appeal.
Exactly. Yeah. And when you're not getting anything in the bargain, it's not a bargain. And you're signing off on a plea bargain agreement that does not provide any corresponding value to your client. I mean, you're getting exactly what the law provides already. So it's not one of those things that you should enter into lightly. Now remember, let's just speak in general terms. In a lot of these cases, our clients are in fact guilty. They've admitted guilt to us. That's not the be all and end all for us.
But in federal court, it's guilty to what? Is it guilt? These conspiracy cases and some of the.
Well, you've engaged in the underlying conduct. You've trafficked the narcotics. You did so knowingly and intentionally. You received remuneration from them, and so there is some guilt associated with that behavior.
Let me give you a war story though. I did a plea about a year and a half ago that was, I won't get into it, but I will say that case, we didn't enter into a plea bargain. And in fact, the case was reversed. And my client did get 3 years off of his rather lengthy sentence. So that justifies what we were saying, why locally it's probably not advantageous to enter into a plea bargain in federal court, because you give up your right to appeal. Are
we looking at any of the questions that are coming up?
There are ways to appeal, though. It's from a weaker point, right? Tristan Stanberry. Yeah. There's all kinds of ways to appeal, Mr. Stanberry, but it doesn't mean you're going to win. I tell you, I find very few cases that I can't come up with something valid to appeal on.
Yeah, but when you're talking about appeal, you're not talking about just simply going through the motions of filing an appeal. That's not going to go anywhere. Now, if you, in a federal case, have signed off on a plea bargain in which you waive your right to appeal, you can still come back later and say, you were improperly advised. You should not have given up that valuable right. There are direct appeals, and then there's indirect appeals. And so we can get really into the weeds on this. But
Mhm.
you know, if you waive your right to appeal, if you enter into a plea bargain, you've weakened your position. And anytime you weaken your position, it makes it much less likely that you're going to be successful on appeal, which are already, by and large, difficult to do.
Yes. Now, I have heard the Fifth Circuit, again, I had a case that was reversed. I didn't handle that appeal, by the way, but I was the one that preserved the error in my objections to the sentence that were able to win the appeal. But I have heard the Fifth Circuit Court of Appeals, which is in New Orleans over Texas, Louisiana, Mississippi, that recently that they're more lenient regarding reversing cases. Have you found that to be the case?
I've never taken anything up on appeal to the Fifth Circuit. I know Irma Sainz locally does a lot of appeals. You do to the Fifth Circuit. I'm not really. Appeal work is not really my cup of tea. So.
Well, I'm not misleading you. It's been a while since I did take a case up to the Fifth Circuit, but I've done numerous cases up there, and I've had the opportunity to argue up there. But, okay, so what else is the scope of it? The trial penalty cannot be attributed to any single cause. Rather, many shortcomings across the criminal justice system combine to perpetuate. They're calling it an injustice.
Yeah, and really, what struck me about this is that it does not seem to be as rampant in the state of Texas, and certainly not here. We don't really face a trial penalty in our state courts. In fact, I remember Judge Vargas, County Court at Law 1, back when I was prosecuting, which was a long time ago, told me point blank, and I still believe it's his philosophy today, I am not going to penalize somebody for exercising their right to trial, which is what the trial penalty in this report is talking about. In other words, if you go to trial and you lose, the punishment is not going to be dramatically different than if you took a plea bargain. Now, I've in fact found that a lot of times, if you're dealing with, if you're in control of your case, you know what you're doing, you've got a good handle on your facts, and you're well prepared, you can often beat plea bargain recommendations by going to trial. I've done that several times this year, as a matter of fact. I've taken cases to trial, felonies, where I've gotten what I consider bad plea offers, tried the case, unfortunately lost on guilt innocence, but we've actually won the case on punishment, where we get a punishment verdict from the jury that is less than what we were being offered.
I thought Mr. Mark Gonzalez, the new assistant, the new district attorney, was so lenient and was such a friend of the people that the plea bargains were going to be so good. Well, that's not the case, Mr. Eric Perkins.
He's not giving felony cases away. No, and I know where you're coming from. I've been a little critical of some of Mark's procedures, and particularly at the misdemeanor level. It's a buyer's market in the misdemeanor court these days. You can get plea bargains, very, very, very good plea bargains in most misdemeanors. Misdemeanors.
Yeah, and in all honesty, let me interject that. I do believe, since Mr. Mark Gonzalez is our new district attorney, who beat Mr. Mark Skirka, our former district attorney, I do believe he has made a big difference in misdemeanor pleas. Yeah, but in felonies pleas, I haven't found any substantial difference, which a lot of people should be happy about, I guess. Well, depending upon.
I mean, I'm a citizen of this community. I want there to be strong law enforcement. I want bad people to be punished. By the same token, as a criminal defense attorney, they don't have as many experienced prosecutors there as they used to.
That's what Dave keeps saying.
They're not getting trained as well as they should be. And so in a lot of sense, you're trying cases against inexperienced prosecutors, and there's with predictable results. That's not across the board. He's got some very good prosecutors. And I think a lot of very energetic and very ethical prosecutors. That's the good part about it. The bad part about it is I get this overall impression that they're overcharging cases. We've got actually more capital cases, death penalty capital cases pending right now than we did under Mark Skirka, which is a little weird because Mark Skirka was he was a friend of capital punishment. I mean, he sent quite a number of people to death row.
Well, let's come back to that in a second, but sure. I wanted to hit up the idea that I think there's a tremendous difference in state court that a plea can make. I mean, it's I'm sure you've had this year somebody who was charged as a habitual felony offender, 25 minimum, wherein they probably drop that.
Yeah, all the time, routinely.
So that's a big difference. 25 years versus, okay, we'll give you 10.
Huge.
When he's looking at, he's looking at up to life, right?
Correct.
He or she's looking up to life.
And that's
and
because,
then they reduce it below that. So,
right.
And they accept a 10-year sentence. So in state court,
well, because the mechanical difference between
right.
state court and federal court are the sentencing guidelines. In state court, the enhancement that you're talking about, either repeat felony offender or habitual felony offender, are enhancements that the state must also prove. So the state can elect not to prove those things, and they drop away. They fall off the plate. In federal court, those career criminal and repeat criminal enhancements exist as a matter of fact. If the person was in fact previously convicted, those points are there. They show up in the PSI, and there's not a damn thing you can do about it. The prosecution can't ignore them. The judge can't ignore them. Probation certainly can't ignore them when they're scoring your particular defendant. And so that's where the major difference exists between
yes,
state
and it does.
court.
But of course, upon good argument by the federal public defense attorney, he can make good argument. Well, look, this and have you had success with this? This prior criminal conviction is old. This prior criminal conviction is not a violent one. This federal prior criminal conviction, he was a very young person, and in theory, they could go below those guidelines, as stated the last time I researched it was for good reason.
Sure,
but they usually choose not to. Correct?
They choose not to because it's not the palatable thing to do. You've got a person who has got an articulable criminal record. So, you got somebody who has got some history, and then you're making the argument to the court that they should somehow ignore criminal history, which courts are very, very reluctant to do for good reason. And so that's the hardest thing to say.
You know what my guys say? And I'll say guys, even though there's a substantial number of women with criminals now. And when I started practicing a long time ago, there weren't.
No, but there's still, the numbers are so totally skewed out of proportion. Guys are worse than women.
Well,
there are some women out there who behave very badly, but by and large, there are more badly behaving guys than there are badly behaving women. So that's just the way it works.
Well, and I forgot the point that I was going to make. It had to do with the possible sentences. But as an aside, before I forget this point, Mr. Conservative, Mr. Trump, the reviled person by the left is encouraging the dropping of the minimum of 10 years sentences on federal criminal drug cases.
Heavily discussed in this report. You didn't get to that point. Mandatory minimums have a disproportionate effect on minorities, persons of color, the disaffected, poverty-stricken, because they almost always pertain to drug offenses. They don't usually pertain to violent offenses. And those mandatory minimums can be they're 5-year mandatory minimums and they're 10-year mandatory minimums. And it's difficult to drop below those mandatory minimums. After your PSI has been scored, you may come in at 67 months and boom, you run into that mandatory minimum. And if you're not safety valve is a way to avoid or escape the mandatory minimum. And that's usually only available for first-time offenders, for nonviolent offenders. And so most people run into that mandatory minimum wall, and regardless of what their scoring for the PSI was, boom, they're stuck with an automatic 5 or 10 or sometimes even a 20-year sentence, which is bad stuff.
So as to recap, anybody who just joined us, then this again is Mr. Eric Perkins. We're talking about an article from the National Association of
It's
Criminal
not an
Defense Lawyers.
article. I'm not going to keep correcting. It's a report. The report they created. We can show. Can't we show this?
Yeah, of course you can show.
Let's show the little cover.
I don't think
they'll love it.
We don't have the cover.
Maybe they'll
ran
give.
out of ink.
Oh, you didn't print the
Didn't
cover. I would have maybe gotten
There's
like a free
cover.
membership next year.
Oh, of course.
That's what I was gunning for. Anyway,
But at any rate,
there you go. That's close enough. It's got the logo.
but at any rate, this is the
Some attribution.
What do you refer to again as it?
It's the report, the trial penalty report.
Okay.
It's only a couple months old.
Okay.
It's new stuff.
And as I was stating,
Available
the
on the
biggest-
internet free of charge.
maybe the biggest federal criminal reform in maybe my lifetime is this this new law that President Trump plans to pass, reducing the mandatory minimum of 10 years on many of the drug cases to 0 years.
Yes.
Which will give tremendous Now, how is that going to? Now,
it's one of the recommendations made in
this
report.
This is very complicated because I have a case pending right now where my client is the criminal defendant is looking at a lengthy sentence, and at what point is it going to kick in?
Well, what is really important is whether or not he's going to make it retroactive.
Right.
And the retroactivity would be very helpful because our federal prisons are clogged with drug offenders, and if he makes this dissolution of the mandatory minimum sentences retroactive, a lot of people are going to be getting out. A lot of people, they're going to recalculate sentences. They're going to be able to request recalculation of sentences. And for a lot of people, that's going to be automatic because those sentences are going to be there in the files.
Well, you're talking about retroactive. I didn't have hopes for that. I thought maybe, depending upon the time they were indicted,
if you're going to say that it's fair to eliminate mandatory minimums, you got to do it retroactively. That's the only thing that makes sense.
Well, what I'm I have a person right now who was on what they've read federal probation. We call it federal probation, but it's actually called something else. But for the sake of the community supervision, and he was sentenced under those minimums.
Sure.
Now he's got a revocation while on community supervision. And I was going to make the argument in equity. Well, Judge, look at his lengthy sentence that he received in the first place. Now you want to revoke him and give him additional time when the laws, if it doesn't go retroactive, when the law has been changed. Will they buy it? Sometimes these judges.
This report will give you a lot of ammunition toward the argument that the original sentence imposed probably shouldn't have been imposed because the court did not exercise nearly as much autonomy over the sentencing process as it should have. The court placed too much emphasis on the sentence guidelines and didn't consider enough factors outside the guidelines in imposing the sentence. And I don't know any of the judges here that wouldn't listen to that argument. Rainey, I don't know. I mean, Judge Head, Judge Jack. I think they were
I'm invoking my right to remain silent. Anything I say can and will be used against me in a court of law.
Probably. I would hope so.
I'm not going to address the judges buying in any way, shape,
you know
manner,
me.
or form.
I'm always willing to run out on these limbs. So.
Well, that's good for you. I've been doing this show a long time, and hopefully I'll continue, God willing, to do it.
That's right.
A defendant
FCC's coming in right now.
A defendant who wants to receive a substantial assisted departure ordinarily must offer to disclose information that the government does not already have.
Right.
What I have found in federal court, it's not the information the government doesn't have. They want to be able to prosecute someone.
They want somebody else.
Want somebody they can indict.
Yeah, they want an endless chain of easily prosecutable defendants, and they discuss this in the report as well.
Okay.
How these sentences and how the methodology of the sentencing guidelines results in just an avalanche of people being incarcerated. Because by and large, all of these people who were given up as a result of cooperation are also facing prison sentences, down to possibly even the lowliest minimal participant who is arguably within this conspiracy. They're all facing prison time. So it's not like we're punishing people or trying to clean the streets of low-level offenders. What we're doing is just stuffing our jails full.
Well, our prisons.
Prisons, yeah.
Even when I started many years ago practicing criminal law, and I remember one of the judges seemed to say kind of haughtily, "Okay, you're sentenced to 30 years." And I felt like I wish I could have said, I felt like saying, "Well, that's real good, Judge. You just sentenced every man and woman in this courtroom to paying taxes for the rest of their lives to keep this person in prison on what I thought not a very serious case."
Now, in the comments section underneath this post, we're going to have a lot of people talking ultimately about, well, you know what? You do the crime, you do the time. Yes, there are consequences to society, but what is the greater consequence to society? To not putting dangerous people. Can we measure everything in terms of dollars and cents? No, you can't. But at some point, you have to do a cost-benefit analysis to this because it does cost a lot of money. So let's segue real quick into capital punishment and capital trials in South Texas.
Capital punishment means a death sentence.
Yeah, death penalty case.
The death sentence wherein someone is charged with, for example, capital murder, and they're looking at perhaps receiving the death penalty, which is how many states have the death penalty? Do you know approximately how many?
Texas does. I know that.
And we know Florida does.
Yeah, well, that's quite a few states have the death penalty stuff. And other states have executed people this year. We've executed more. Capital cases don't always have to carry the death penalty in Texas. The state can choose to waive the death penalty, and if they waive the death penalty, then the maximum punishment for a capital case is life imprisonment without the opportunity for parole, which means we warehouse this person for the rest of his natural life, which in some cases can be a long time for younger offenders. You know, if somebody in their late teens or 20s can spend, you know, the next 60 years in prison at public expense.
And I hate to get, but I did want to mention, of course, there's supposedly this big problem regarding older offenders being in prison. There's so many now, and the costs are so exorbitant with health costs, et cetera. All
right. Well, let's get one thing really clear. You're not getting great medical treatment when you're in prisons. You're not going to get any exceptional medical treatments. They're not going to go out of the way to save your life in prison. Okay, let's get that out of the way right now. Nothing is better in prison. Stay out of prison. Stay in school. Avoid prison at all costs.
No, don't stay in school. Go to work.
Yeah, don't stay in school. I'm talking to my sons right now. Zach, Landon, you need to graduate.
Stay in school, but have a plan. Do not become institutionalized by school. I've seen it happen. Perpetual students. And
we're getting way into the weeds now.
Yeah,
we need the two ferns. We need to have the two ferns.
You say go to school. I want people to know school is a way to go to work.
I'm talking to you people in middle school and high school. Graduate from high school. Go to college if you need college. Go to a trade school if that's where you're going to go. My point is stay out of trouble.
In the famous words of Bob Dylan, they'll put you on the day shift. 20 years of school.
Yeah.
No, so we were talking about the capital murder.
Yeah,
capital murders, for example, and the death sentence.
Right.
And you think that the new district attorney, Mark Gonzalez, who's always welcome to come on the show. He's been on before he won the election and respond. You think he's asking for the death sentence in too many cases?
Yeah, I mean, just because the particular facts of a crime fit the 1903, which is the Texas Penal Code reference to capital murder, meet the criteria of 1903, doesn't mean you have to charge it as a capital murder. I mean, if you've got a young offender who has no criminal history, who just happens to have been involved in a situation, again, everybody's presumed innocent until they're tried by a jury, where there's a number of ways you can commit a capital offense. You can kill more than two people in a single action. You can kill a child under the age of 5 years. You can.
I think it's kill 10 or 8 now. I think it's been changed. Go ahead.
Well, sure. Okay. Well, that's fine too. Or you kill somebody during the course of committing another felony, the felony murder statute.
Yeah. For example, during a robbery, if you commit murder during a robbery,
you can be charged with capital murder. So, because you can be doesn't mean you should be. And here's the reason why. Capital murders, particularly capital murder where you're seeking the death penalty, are extraordinarily complicated, expensive affairs. It would be almost impossible for a criminal defense attorney. First of all, the Texas Code of Criminal Procedure has some very strict things that a court has to do if somebody is charged with capital murder. First of all, they have to be appointed not just one, but 2 attorneys. Those attorneys, at least one of whom has to be certified to try capital murder cases, death penalty cases in the state of Texas. They have to appoint a fact investigator, at least one fact investigator. You have to appoint a mitigation specialist. The mitigation specialist is there to deal with the punishment issue of mitigating circumstances. So it's a real complicated scenario that runs into a lot of money very soon.
Let me interrupt you. Supposedly, it's well known in the legal community that the reason that these laws were talking from a right-wing perspective, the reason these laws were passed is to make it too expensive to actually prosecute a capital murder case.
Well,
so and it's worked successfully. Supposedly, the counties around here, Jim Wells, San Patricio, etc., almost never ask for the death penalty because they can't afford it. So it has acted as a deterrent to asking for the death penalty. Are you aware of that argument or discussion?
Of course. And in fact, they've done a workaround on that by through the Texas Defender Service, the capital project, where counties in this area pool their resources to get the Texas Defender Service to provide capital defense for their indigent
counties.
Their indigent counties. They pay a flat fee every year in order to participate in that. Nueces County is not one of them. Nueces County capital defense comes out of the normal pool of persons who are certified to defend death penalty
Speaking
cases.
practically on a capital murder case, to act as a criminal defense lawyer, what is the average bill? $20,000 to $40,000. A criminal defense attorney's pay $20,000 to $50,000.
Yeah, it's usually 50 up.
You know what?
50 up.
I do those.
Court appointed attorneys are going to bill between $50,000 and $80,000.
Yeah,
and that's two of them. There's two of those attorneys who have to be paid. And if they do their job correctly, they put the time in, they're adequately prepared, they do the proper pretrial investigations, they do the proper motion practice. If they do everything they're supposed to do, following the ABA guidelines and the state bar guidelines for capital defense, which not everybody does, but they're.
How long does a capital murder case usually take to try?
Well, the jury selection alone can range anywhere from 2 to 4 weeks. That's picking from a jury pool of upwards of 300 to 500 people. You have to pay for all the jurors. The court is virtually shut down during that period of time as well. 2
to 4 weeks for the jury selection and 2 to 4 weeks for the facts.
Yeah, it depends on how complicated the facts are, but certainly about a week, maybe 2 weeks in a complicated case with a lot of witnesses. 2 to 3 weeks is not unheard of. Even when they waive the death penalty, a complicated fact case can take 2 weeks.
So you were talking about whether or not the district attorney should oftentimes go for the death penalty, and you were talking about obviously the expenses. What is a mitigation expert that the criminal defendant is always entitled to have a mitigation expert? What does a mitigation expert do?
Mitigation expert investigates the life circumstances of the defendant to investigate whether or not he has any intellectual deficits, whether or not he has, his criminal history, his mental health history, his family history. A good mitigation expert will go back 3 generations looking into whether or not there are just things about the defendant which led this crime to happen. A jury is entitled to hear anything that is considered mitigating.
So the mitigation expert does a report and
can testify in some rare circumstances, yeah. But they generate a fairly comprehensive report involving investigations, in document gathering and things like that.
And how does the criminal defense attorney, if the mitigation expert doesn't testify, there's no report, then he goes into the facts and he says, look, this man or woman was severely beaten as a child, was sexually molested. How do you get that into evidence at trial?
You'd call the individuals. You'd call teachers, you'd call medical practitioners, you'd call family members, you'd call other professionals, mental health professionals, things like that. The mitigation expert largely is an information gathering specialist, brings in all the documents, brings in all the records, gets the names of the witnesses, interviews the witnesses, provides you synopses of the witness testimony. It's very time-consuming process, and it has to be started at the beginning of the case.
So you find great validity in it, the way you're talking. You're talking very sincerely about the mitigation expert. You're not speaking cynically.
No, absolutely not. Because again, the difference between a death penalty case and a regular criminal case is very important. At the punishment phase of a death penalty trial, the jury is not asked to consider whether or not the person should be sentenced to death. They're asked 2 questions. Is there the likelihood that this defendant will commit acts of violence in the future? The second question is whether or not there exist any circumstances that would mitigate against the imposition of the death penalty. So the first question is this person bad enough that we are to expect them to commit acts of violence in the future? And second, is there anything that we should think about? Is there any circumstance that would mitigate against killing this person? The person who actually imposes the death penalty in a capital case is the judge. And so the jury will answer those questions.
Based on whether or not the jury answered those questions affirmatively. Aren't there 3, I'm sorry to say this, because I haven't,
There is a potential third question if it is a multi-defendant case. The third question would be, did this defendant actually kill the person? So they say you can have a guy shooting a gun, and you
Right.
can have co-defendants.
Right.
And so
so that gets around the. So it is still the case in Texas. If you are a legal party to a murder case, say on a burglary, and you did not do the shooting, you can still get the death sentence. Is that wrong or right?
Yeah, and it's happened a lot of times in Texas. You can actually not kill somebody and die in the state of Texas. You
could, and just since you were talking about young people, you could drive one of your friends to a burglary, and if he or she shoots someone in that burglary, and you knew he was going to burglarize that Circle K or 7-Eleven or store, you will be looking at the death sentence in all likelihood, even though you didn't know he was going to shoot anyone.
That's right.
Because it was a likely outcome of that robbery, correct?
Yeah. In fact, we just we tried one of those cases where we had 4 defendants this year. I tried the first case, and then David Klein tried the last defendant. The other defendants either accepted plea bargains, or they accepted plea bargains. One of them, I think, got a dismissal. But yeah, no, everybody faced the same punishment because were all charged with the same crime. In this particular case, the state ended up waiving the death penalty before we went to trial, but it was
Since we're talking about war stories, I have a specific example of a case that I'll say in the last 3 years that basically I said, look, just take the death penalty off the table. We'll go to trial. So he gets his right to a trial, and this county doesn't have to spend all this money.
That's the main argument.
Take all of this time, and then that way everybody's happy. The case against my client, well, I won't say how it was strong or weak, and the judge was in basic conformity with what I was saying, because that county money is a lot. And by the way, I haven't had a court appointment, unfortunately, in many years. Another part of my life that we won't get into.
If you're not on the list,
no bitterness, huh?
If you're not on the list, Mark, you can't get the appointment.
I don't even know what list there is. Where's this list, man? Is that like the good or bad list? Is that like Santa Claus list?
Yeah, checking the list, making the list, and checking the
You know what? I don't want to put down when they started, whatever it was, 15 years ago. You got to put down your school. You got to put down.
You have to admit that you went to law school. Yes, you have to do that.
Hey,
you have to give them kind of a synopsis of what you've done.
Okay, whatever.
Get your ego out of this, man. Get your ego.
I'm not on my knees.
All right.
So we're talking again about. So on the capital murder cases, it's going to be very expensive.
Okay, well let's go back to what we were talking about. All right. So in my humble opinion, Mark Gonzalez is charging every capital case that comes down without respect to the provability of the capital aspect of it, the death penalty aspect of it. Now, Tarrant County has adopted a way of screening its capital cases. They formed a capital committee, and it consists of a couple members of the DA's office, a couple judges, a couple of defense attorneys, and some just members of the general public. And when a capital case happens, when somebody commits a capital crime, this committee gets together, they review the facts, a little bit like a grand jury, but different. And they decide whether or not this case is worthy of seeking the death penalty. And they go, that committee's decision controls. And it's worked out very well for them. The legitimately capital cases, the people who deserve the death penalty, those cases get charged and go to trial. The ones that are just nominally capital cases, in other words, they meet the strict requirements of 1903, but don't really meet the requirements. Like, for instance, Hannah Overton. That Hannah Overton case should never have been charged as a capital murder.
But that wasn't under Mark Gonzalez. That was under Mark Skirka, wasn't it?
It was under Mark Skirka.
They had quite a team at that point.
They had
quite a team of experts and a prosecutor that were prosecuting those kind of cases.
Right.
They worked in conjunction pretty good.
Yeah, they had prosecutors absolutely capable of prosecuting a death penalty case, and they did so. And regardless of my opinion about whether she didn't get death, she got life in prison without parole. But the point was, she's now been exonerated. She's been cut completely clean.
And that's political too, isn't it?
Well, that aside, whether there is some component of that,
I'm just teasing.
It was a huge amount of money spent, taxpayer money and private money, to get to the point where she was before the trial started.
Right, and she paid a lot of money in order, I'm sure, to get exonerated. And if she wouldn't have had that much money, she may not have been exonerated.
But
so money's a part of it, right?
Because she was actual innocence and ended up in prison, I think there is a pretty strong likelihood that she was compensated at the rate of $80,000 per year for every year she was spent in prison. So, I mean, there is an end result to that. Some remuneration. I don't know that. I'm not going to swear that it happened in Hannah's case, but it's available. We wrongfully convict an actually innocent person, and they go to prison. The Innocence Project has recovered an awful lot of money for people in the state of Texas, people who were definitely wrongfully convicted.
And by way of explanation, and correct me if I'm wrong, there's a specific statute in the state of Texas that allows payment of, Mr. Perkins saying, $80,000 a year if you're wrongfully convicted and you're later exonerated.
That's correct.
And I don't know if I had not read that she received it or that she was eligible.
I don't know that either. It would seem that she would be eligible, but I mean, there's always that to consider as well, that we end up picking up the tab for this. And me and you and anybody who's watching, any taxpayer in the state of Texas, we're funding this. This money isn't just plain money. It's costing us both capital, and it's costing us in terms of our souls as well whenever we convict somebody wrongfully.
Isn't the likelihood of a wrongful conviction, hasn't it been reduced markedly by that Morton decision, wherein all the evidence is allegedly going to be submitted to the criminal defendant and to his defense attorney? Don't you think that has reduced markedly the possibility of being wrongfully convicted? Because I would,
if everybody plays by the rules, if everybody had played by the rules that existed, Gideon versus Wainwright and Brady versus Maryland, those cases would have ensured that these wrongful conditions didn't happen. But the truth is, we have human beings involved in this process. We have egos involved in the process.
Politicians.
We have lawyers, lawyers who like to win.
We have judges.
That's right. Well, no, but it's true.
You know, they're elected.
You can't ignore the fact that the human factor in all this is the unknown. You've got prosecutors to this day who are not turning over evidence. You have police officers who aren't turning over evidence to prosecutors.
Have you had that problem?
Yes.
You have?
Yes.
Interesting.
3 weeks ago in San Patricio County, we had just started a narcotics trial.
Go ahead.
Well, no, it's common knowledge. We started a trial. The first witness on the stand started throwing out evidence that had not been disclosed to the prosecutor. It wasn't the prosecutor's fault, and I told him I don't hold him responsible for any of this. But he had not gotten the evidence till the day before the trial started, and he didn't get some of the evidence until the witness was on the stand. I asked for my continuance, and
denied.
No, actually, the judge took a recess over lunch, and the prosecution, to their credit, considered the circumstances over the lunch hour and ended up dismissing the case, which was the right thing to do. So, but human beings are imperfect. But so as long as we have human beings in this,
let's get back to that. But they dismissed it without prejudice.
No. It was jeopardy had attached. We had a jury seated. They had been sworn. The witness had testified.
Okay, so
it's over. That case is over.
That was excellent. That was excellent.
Well,
I must admire the district attorney.
He did the right thing. Obviously, it was frustrating for them because they had a pretty good case. But human beings are not perfect. Our cops are overworked. I represent a lot of police officers. They are overworked. They are asked to do more with less money. We have seriously understaffed police departments to do the job that we need them to do. There's no money for these. The city of Houston just recently renewed a fire department contract. I think they lost a lawsuit. The firemen won, and they're having to figure out where to find this extra $100 million with which to fund these firemen. There isn't enough money to go around. We are increasingly asking our governments to do more with less. And so what happens is those who are least capable of defending themselves, I believe it says in the Bible, inasmuch as you have done this unto these, the least of thy brethren, you have done it unto me. We are talking about the people in our criminal justice system. They are the least of these thy brethren. They are the people who are least capable, least able to defend themselves. We have to do that for them. It is our job to defend them with the resources that we have at our disposal. And if we don't have those resources, we have to come up with them. It's our ethical responsibility to provide the knowledge and expertise to defend these people. You know, Clarence Darrow, known as the attorney for the damned, the people who have no friends. Literally, they've committed such heinous crimes that nobody, even their own families, won't defend them anymore. And we are left, as you were in your case in Victoria, defending almost the indefensible. But you still
it was not an indefensible case. I had a very strong case.
But you did the job you had to do to defend that case.
I was very disappointed by the results and other things in that case.
We often
God willing,
we often are.
God willing, we'll win that case on appeal. See, because of their vast discretion in charging, prosecutors can threaten 924C enhancements if defendants refuse to plead guilty, and this is in federal court.
That's a federal
What's a 924C enhancement in federal court? Do you recall what it is?
Not off the top of my head.
Okay, defendants will know that they have no hope of leniency at sentencing because the enhancements are mandatory. Thus, exercising one's right to trial becomes a treacherous route.
And that's kind of what I was talking to you about, the state versus federal. The enhancements in state court are not mandatory until you get through the guilt innocence phase of a trial and you get to punishment. Once you get to punishment, those enhancements are there, and the jury really has its hands tied. I mean, if the evidence is put on that you have prior convictions, they put the pen packs in. You know, you prove up the guy's prints on the judgment, so on and so forth. It's a rare jury that's going to say, no, he doesn't have a prior conviction.
This article also talks about the three strikes rule, the severely punished. We don't have a 3-strike rule. That's
you kind of do.
No,
Texas does too. Mm-hmm. That's a repeat felony offender or a habitual felony.
No, that's true. They have
and we have some statutes right now. The aggravated sexual assault of a child starts out at a minimum 25 years.
And you have the enhancements, the shoplifting to a felony. You have
exactly.
You have the enhancements.
Judge Klager famously gave the example of stealing 2 pencils, getting convicted for each pencil theft. Your third pencil is automatically a felony. So, I mean, in a sense, we do have a 3-strike rule. Fairly innocuous offenses. I mean, even stealing a loaf of bread to feed your children, that's not, that doesn't get you off the hook in the state of Texas. You're still guilty of a crime because we don't have any concept of mitigation built into our punishment. We have the range of punishment. The court can certainly sentence you at the low end of the punishment range, but the court can't not punish you.
And I think I was unaware in your report, another weapon prosecutors have to coerce guilty pleas. 18 United States Code Section 3559C, the 3 strikes rule, which mandates a sentence of life imprisonment without parole for any defendant convicted of a violent felony who's previously been convicted of 2 or more violent felonies. I don't think I've ever had anybody in those fact circumstances.
No.
Have you?
No, I haven't. Happily, no.
And and what's the difference since we're talking about the difference between federal and state? If I'm given 10 years in a state in state court, I'm given 10 years in federal court. What do I serve in federal court? What do I serve in state?
Well, first of all, you have to talk about where you're going to be serving that time. In state court, you're going to Texas Department of Criminal Justice, which is not a pleasant place to go. These are not wonderful prisons. They are not state of the art. They are not great places to be. At least in the federal system, Bureau of Prison, unless you get sent to one of the grimier prison camps, they're generally better facilities to go into. There's more programs available. You're going to generally get better food, commissary, medical treatment than you would. However, you're probably going to do more time on the federal side.
80%, I believe, right?
Correct. Than you will on the state side. Now, the difference between the federal sentence is that you do have your mandatory, your supervised release after you finish your sentence. And in the federal system, as opposed to the state system of parole, supervised release, if you manage to screw that up and you get revoked, you could conceivably be on supervised release the rest of your life if you keep going through revocations.
It's 6. It could be, depends. It's a lot of times it's like 16 to 24 months, and then if you're convicted of another crime, it's in addition.
Sure.
So it's pretty rough. And
whereas on the state side, you'll get out on parole depending on the type of offense you've committed. Generally, drug offenses and nonviolent crimes, you'll get out on parole fairly quickly. After just a short portion of your sentence has been served, possibly as little as 10% of your sentence has been served.
And of course,
and you're getting good time at a much higher rate, good time credit.
And explain the differences between in state court. Let's say that you have an aggravated sentence or you have a weapon versus straight time. It's a significant difference of time that you could actually serve in state court on a 10-year sentence.
Right, and this is hugely confusing, particularly to people who are already in the system, such as the Nueces County Jail or the other jails. You get inmates talking to inmates, and you get into these very convoluted conversations about aggravated versus non-ag. The general rule is that for a non-aggravated offense, say a simple theft that happens to be a felony, and you go to prison for that, you're going to have to do at least 1/4 of your sentence before you're eligible for parole. That's the general rule. Circumstances can intrude, but that's the general rule. So if you got a 10-year sentence, you're generally going to look 2.5 years before you're eligible for parole. Okay? General rule. Aggravated offenses such as robbery, kidnapping, things like that, more serious offenses, you have to do half of your time. So somebody who is sentenced to prison for murder is going to generally have to do half of his time before he's eligible for parole. However, the way it actually works out in TDCJ is that for aggravated offenses, they're doing most of their sentences.
Right.
The bad guys, the bad guys are generally not getting parole.
But that's
sex
now.
offenders.
But that's now. It changes depending upon how much bed space they have, right?
Bed space and legislation can change it. So a sentence that's handed down today could be changed by an act of the Texas legislature next year. Some of those things are retroactive. So there's really no way. And it's built into our plea bargain agreements, and courts will admonish you right and left. Nobody can tell you how much time you're actually going to do.
It makes it harder for a client to accept a plea, not knowing how much time they're going to do, right?
Sure.
I mean, and then if you're a gang member, it's my understanding that they serve longer time. Have you heard that from the guys?
Yeah, and they face different circumstances. They're generally classified when they get to TDCJ. They're put into units with other members of the same gang. And even if you disavow gang membership, you're probably still going to be treated as a gang member once you get to TDCJ.
And the fact that allegedly you serve a longer sentence if you're a gang member in Texas prisons, now called Texas Department of Criminal Justice, I think is unfair because they haven't proven that beyond a reasonable doubt, your gang membership, right? So you don't care?
It's not an element of the offense. No, I care.
I'm just kidding. I'm just kidding.
But the thing is, gang membership sometimes can prove benefit once you're in prison.
That may be something that I appealed at one time.
Hey, try everything.
I'm time traveling.
Try everything. Throw it out.
You got to try it.
It's not going to hurt.
I was in federal court the other day, and I told my secretary, "Okay, we're going to argue this. It's not going to work, but you got to say something."
Well, you never know what's going to work.
Do you know that I had a case wherein the law had changed? I can't remember. The law had changed back, and I said, "Well, Judge, the law just changed, so I'm going to object anyway." Overruled me, and then the law changed again.
Sure. Oh, yeah. When you're talking about predicate questions and objections during trial, the best advice is to object, preserve the record. But we're really getting into.
Yeah, let's talk about that. We only have 3 minutes left, so we only have like a minute left. But
seriously, how much time have we done?
57 minutes.
It doesn't seem like any
according
time
to YouTube and Facebook.
We must be having fun.
Yeah. So, but isn't it also true that some people believe that if you object too much, you'll seem unreasonable. It'll be harder to present your case and harder. There's some people who believe that.
I disagree with that because I try cases all the time. Jurors expect to see attorneys doing their job. And if you properly select your jury and you prepare them for the fact that you are going to vigorously defend your client, neither judges, prosecutors, nor juries will ever hold it against you. On the contrary, I think juries look very harshly on attorneys who sit there and do nothing. They expect to see us standing up and vigorously defending our client. If you get up and you make an ass of yourself, it doesn't matter where you do that. You can do that here in your office.
Do it here.
You can do it in the mall, but you can't afford to do that here
because
it's better.
It's better because you pay for the people here.
And can I maybe talk you into getting the two firms, because I think we'd have a lot of fun with that.
Yeah. Well, thank you very much for coming on. This has been Eric Perkins. This is the end of our show, and Mr. Perkins got on the soapbox. But I want to thank everybody who watched, and next time, ask some questions. Thank you very much. Bye-bye.